Okay, here we go. Defense rebuttal. Now, this is a pretty good maneuver by the prosecution here. So the defense is finished. They did their last closing. They're done. The prosecution gets one more bite at the apple, and they switch DAs. I think they're figuring out that Binger, because he was attacked, because the witness called him a liar, because he's been weaselly and sleazy and has gotten caught so much in his trial being sleazy, this guy comes off a little less involved or personal to it. So they're going to have him do the rebuttal. So this is really good for the prosecution because they have two different witnesses. They both get a chance to win the jury over, and the defense only gets one and one time. Here we go.
It simply cannot be reasonable for someone to be holding an AR-15 semi-automatic rifle with powerful ammunition and be chased by someone who is unarmed, who's smaller than him, who's shorter than him. And the first thing that you do to defend yourself is you plug 4 rounds into it. You shoot it from about 4 feet away, and not from 4 feet from Mr. Rittenhouse, 4 feet from the end of that gun. Your first shot immobilizes him. It shatters his hip. Then he's caused to go forward. And if you watch the videos, and we're going to watch a couple during this brief rebuttal, he crumples. He immediately crumples to the ground. No one is saying that Mr. Rosenbaum should have chased Mr. Rittenhouse. No one is saying that Mr. Rittenhouse did not have a right to defend himself. This case is about the right to use deadly force. And I want to talk about...
Well, I'm glad he said no one's saying he didn't have the right to defend himself, because it sounds like that's what they've been saying the whole time.
That standard, because Attorney Richards, perhaps on accident, misstated it. He said that the standard is that it could cause death or great bodily harm to Mr. Rittenhouse, or that it is likely to cause death or great bodily harm to Mr. Rittenhouse. That is absolutely not what the standard is, and that is not what this trial is about. The standard is the defendant may intentionally use force which is intended or likely to cause death or great bodily harm, such as fire an AR-15, only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. Not, oh, if you repeatedly smash someone's face, it might lead to injury. Not, oh, this could have happened. Imminent death or great bodily harm. There's an old phrase that I could kill you with my bare hands. And there's literally no evidence that Mr. Rosenbaum was capable of that.
What did you want? You wanted him to wait to be dead to find out if he could? That's brilliant.
Mr. Rittenhouse has size on him. We heard how he's a swimmer. We heard how he's a lifeguard. He's apparently in some kind of shape. Punch him in the face. Kick him in the testicles. Knee him in the face. Hit him with your gun. You don't just immediately get to shoot someone. And I don't care about provocation or any of that. Put that aside. It is not reasonable for any adult, for any person, for any 17-year-old male to not try and defend yourself first using other methods. Now you factor in provocation, the fact he had no right to retreat, or no ability to, or he had to retreat, and that he had to exhaust all methods. Clearly, if there was provocation, he's guilty. But even outside of provocation, why do you get to immediately just start shooting? As Mr. Binger said, he brought a gun to a fist fight. And he was too cowardly to use his own fist to fight his way out.
Oh, so now he's a coward. He's a liar, a 17-year-old liar, coward, and was attacked by 3 adults, all criminals, and he's a liar and a coward. Man, these two make a great team of being weasels.
He has to start shooting. And let's just say, theoretically, that we think, that the 12 of you think that it is reasonable to have used force, deadly force in that situation. Shoots once, takes out his hip. What does Mr. Rittenhouse have to do to avoid that? Well, maybe take 1 step back. And Mr. Rosenbaum is no threat.
You can't even take 1 step back in 3/4 of a second. You big dummy. He fired 4 rounds in the time you took, less time than you took a step back.
And Mr. Rittenhouse is responsible for every round of that gun. It did not have to happen as fast as Mr. Rittenhouse made it happen. He could have held back at 1 shot. He could have held back at 2 shots. The guy in the blue hoodie who came in to attempt to kick him didn't get 4 shots. Mr. Rosenbaum didn't get 4 shots. And Mr. Gross-Kreutz did not get 4 shots. The defendant has the ability to gauge what he is doing and to stop shooting. Mr. Richards talks about the threat being immobilized. What threat does someone 6 inches shorter than you that you've already shot in the hip and is already falling to the ground have? Why do you have to keep tracking him and shooting him and ending up with a kill shot in the back? Hit him, kick him, knee him, anything else. And Mr. Rosenbaum and Mr. Rittenhouse are
In your case, sit on him.
alive. Because the defense talks about games that the prosecution...
I'm pretty sure if he sits on somebody, that's deadly force. And I'm serious.
Played. Let's talk about games. Let's talk about how Mr. Rittenhouse on that night did not tell Dominic Black, did not tell Joanne Fiedler, did not tell anyone about this grabbing of the gun. Didn't tell anyone about, oh, I was afraid they were use the gun against me. That is because once Mr. Rittenhouse and his team understood that an unarmed person chasing him and unarmed people chasing him later on would not be enough to meet this standard, to meet this privilege, they had to concoct a story. They had to concoct a story about how suddenly I was in great fear of this gun being used. And if that's the real reason, why didn't Jason Mikowski know that? Why didn't Dominic Black know that? Why didn't Joanne Fiedler know that? You darn well know if there was any evidence of the defendant saying that the night of, we would have heard about it. So yes.
Yeah, because when he's so scared, he's 17, he's throwing up, and he's fear, and he's pale, and he's been pounded in the head by skateboards and a boot. He's thinking clearly as you, when you're looking at a case full of donuts and you can't figure out which one to choose.
Mr. Rosenbaum is 4 feet or so from the barrel of the gun. He gets shot in the hip. He begins to crumple. Now remember, we did this demonstration when Dr. Kelly testified. This bullet entered here in the middle finger and came out here. This is how you grab something? I'm Mr. Rosenbaum trying to take this gun away. And this is how I'm going to do it, with my hand turned almost completely around.
That is so freaking ridiculous. Anybody that believes that he spread his fingers like that so the bullet could go in is a damn fool.
And with apparently my fingers spread because these two don't get soot, which may mean they were on the gun or outside of the path, and the other ones do get soot. We're not talking about injuries to the palm here. We're not talking about injuries like this or any kind of grabbing injuries. We're talking about either something accidental or completely defensive to knock that gun away as he is being shot just before he is killed on the 3rd or 4th shot. But we're supposed to believe that Mr. Rosenbaum is Jason Bourne or John Wick or some other movie star hero who's capable of killing with his bare hands and deserved the treatment that he got from the defendant.
Man, they showed the video. Oh, I said Footloose. Somebody else said it was Roadhouse. Sorry. Shows a movie thing from Roadhouse, and now we're talking about John. Man, these guys are really into their movies.
Mr. Richards' closing.
Just for the record, I've never seen any of the John Wick movies, so I have no idea what he's talking about. I think John Wick is some dude that kills everybody, but I don't know.
It was quite personal. If not taking shots personally, Mr. Binger, he was gloating and boasting about his client's kills. And he talked a lot about the Zeminskis. He knows darn well that the Zeminskis are charged by my office, and they have a Fifth Amendment right. This is a criminal defense attorney.
Stop.
Oh, we're getting into oh shit! If he excuses the jury, this is gonna get freaking good.
Stop. Let me ask you to step out for a moment, would you?
Oh shit! Oh shit! Here we go! Yeah! I love it! It's gonna be some weasel snacking time! A little...
What's your objection? It's not in evidence, and Mrs. Zeminski doesn't have a right. Her case has been disposed of, and she did not appeal.
She did not plead or was charged with any arson, which the defense could get into, and she would have a Fifth Amendment right.
Wait a minute. As I recollect, I think I handled the case. As I handled the Jason...
Joshua Zeminski?
What's that?
Joshua Zeminski?
That's pending.
Right.
Mr. Zeminski's case is pending, and it has been repeatedly adjourned to follow this case. At the state's request. I handled the case of Mrs. Zeminski. And she came out on a reduced charge. It was a recommendation, I think, for a 7-day sentence. And
She was being revoked in central prison. I know the pictures of that case. But if Attorney Richards can...
Well, she wouldn't have a right of... I think I sentenced her to 7 months in prison consecutively to her sentence.
So I think what the objection is he's bringing up her right to remain silent, and she hasn't been adjudicated yet, and now the jury and everyone else is going to know that she took the Fifth, and they were already counseled about bringing that shit up because everybody has that right and it can't be used against them. I'm thinking that's what they're going, but they didn't make it clear.
And I don't think... why would she have a testimonial privilege any longer?
If there are charges outside of what she was charged with? She wasn't charged with any arsons.
Are you going to charge her?
I don't know. Probably not.
All the charges of the event. all of the charges out of the event were wrapped up. They can't piecemeal the charges, and to argue that she has a Fifth Amendment right now is ridiculous.
I did say Mr. Zeminski had a Fifth Amendment right, and then the objection came. I did not say Mrs. Zeminski. I can clarify that Mr. Zeminski has a
Well,
Fifth
let's find
Amendment
out
right.
from the report of what was said. I thought it was just Mr.
So now it boils down to what the woman typed in the middle of all this. Because obviously court reporters never make mistakes, right? I mean, all this shit going on in courtroom and they are always perfect. Okay, you believe that?
I think he said that Zeminskis are charged by my
The
office, and they have a Fifth Amendment right.
Did you say the Zeminskis? Both? All right, well then,
I'll clarify.
I'll sustain the objection.
I understand.
All right. All right. Ask the jurors to come back in, please.
I thought he got into Zeminski and Kyle about the Fifth Amendment. He just said the Zeminskis, I guess. I thought he was bringing up Kyle.
Because the statement which was made by Mr. Krause was not accurate, at least as regards Mrs. Zeminski. Any question? Go ahead, Mr. Krause.
Ms. Zeminski was charged and convicted by my office. Mr. Zeminski still has pending charges. Attorney Richards knows that he has a Fifth Amendment right to not testify.
Let me ask you to step in the library again, please.
What the mother?
One, it's not in evidence. Two, if he wants to say he has a Fifth Amendment right, they also can grant him immunity. They're the only people who can. And if they're going to say that, I should have a rebuttal to explain it to those 12 people. They hold the keys to Mr. Zeminski testifying or not testifying.
Correct.
We just heard 2 hours of how terrible Joshua Zeminski was, and the defense wants us to offer him immunity. That's completely
That's not
our
what you
decision.
said, Mr. Krause, please.
He still has a Fifth Amendment right. What I'm saying is accurate.
But you know, the question you're asking, the Zeminski case has been here on a number of occasions, and it has been either it's been a mutual request to adjourn the case. Who's his lawyer?
Mr. Barth.
Okay, it's been repeatedly requested that it be adjourned, and I assumed, or was told, I'm not sure which, that it would be adjourned pending the outcome of this case. No, that's not true?
No. I don't know.
Well, it's not true. It is true that I assumed it. Whether I was told that or not, I don't know.
It's not the same as Dominic Black, Your Honor. It's a different situation. Zeminski's case will go to trial on January 31st.
Well,
That's the plan.
but why was it being adjourned?
I think there was some, we had a witness who was not available at the last trial date, so we needed more time to get them in.
Okay.
How convenient. Till after this trial.
And Mr. Richards also brings up a point that you have control over the availability of a witness in terms of grant of immunity, but I don't want to get into that because I think on the first point he made, which is that I don't think it's an evidence.
I asked Mr. DeBruin about it.
What did you ask Mr. DeBruin?
I asked Mr. DeBruin that when we were talking about our meeting, that he was going to be a witness against Mr. Zeminski, and that Mr. Binger talked to him mostly about Mr. Zeminski because there's a pending case against Mr. Zeminski.
Say again.
After Mr. DeBruin talked about our meeting, on cross-examination, I asked Mr. DeBruin, I believe this was a while ago, I indicated that he was going to be a witness in the Zeminski case, and that Mr. Binger asked him mostly about Zeminski, and why would Mr. Binger ask questions about Mr. Zeminski in an effort to change his statement in the Rittenhouse case? And he had no answer for that.
What's that got to do with the
Fifth Amendment right.
the district attorney is making, or the defense attorney is making?
It's that there's an open pending case against him.
There was specific testimony that there was a trial date on January 31st. That came in through Mr. DeBruin, and I actually mentioned it in my closing because it's in evidence that there's a pending case. I'm prosecuting Mr. Zeminski, and the trial's coming up in January. That is in evidence, Your Honor.
That has nothing to do with the Fifth Amendment, which is
You can't put evidence in your closing. Just because you mention his closing doesn't mean it's in evidence.
what I'm objecting to and bringing that into this.
I don't know.
Okay, I'm a little bit clearer now what's going on. He's trying to dismiss the fact that because the defense said you didn't call him and he's a bad guy and he was starting trials, now they're going to say we're charging him and he has a Fifth Amendment right, or we would have called him. It wasn't our fault. That's bullshit, because the DA can give him limited immunity to testify on this case that doesn't go against his penal interests, and his lawyer could have approved. They didn't want him to call because it hurt their case. And now they're trying to lie and weasel the jury in that there was legitimate reasons why they didn't call him. It's bullshit. And the defense is right. But the DA, pulling their dirty tricks.
you're making it sound as if, well, you're making it sound incorrectly so, that Mr. Zeminski is unavailable because of his testimonial privilege. But now Mr. Richards is asking whether he should be allowed a rebuttal to, so the jury would understand
Good.
that that is somewhat under the control of the district attorney.
Good.
But I'm not going to, at this point, I'm not going to get further into that. I'm just going to ask you to move on to something else.
Shit.
Well, my next line of argument is that the defense named them in their witness list and could have called the Zeminskis.
No, he can't, because he's got a Fifth Amendment privilege for the very reason you indicate, and privileges must be claimed as much as possible outside the presence of the jury. That's the statute.
They could have called Kelly Zeminski. They admitted her here from prison.
Pardon me?
We had to have her available in case something came up. That doesn't mean we have to call her. We have no obligation to put anybody on the witness stand.
Nor does the state. And
The state is-
Mr. Richards commented many times about how we could have called them, which I think was dishonest given the Fifth Amendment issue. But then also I can mention that when he set up and read his witness lists, the Zeminskis were on it, and they have the ability to call them as well.
The witness list is not in evidence.
These are opening statements, and he commented on those multiple times.
I don't,
This is a tough one. When in doubt, rule against the government. Always. The government has all the power. They shouldn't be making mistakes. The burden's on them. When in doubt, rule or vote against the government.
What was the last statement you made now that drew the objection?
That Mr. Zeminski has an open case and a Fifth Amendment right.
Yeah. Well, that is an accurate statement.
That I should be able to fill in the holes because they're the ones who can give him immunity. I can't call them.
Well, I know that, but
I know that, but he's right.
you know.
He was saying
No. You address your remarks to me, both of you. To me, not to each other, please.
I'm prepared. I don't know what's going to happen at a trial.
Okay.
The prosecution has been dirty this whole trial. Hold their ass accountable.
Well, I think I'm just going to tell the jury that Mrs. Zeminski would have been available to be called by either party. Okay?
Oh, that's bullshit.
Oh, man, I got out of it alive. Okay. Ask them to come in, please.
More games the jury doesn't know and has to figure out what's going on and what lies are being told.
All right, folks, what the situation is that Mrs. Zeminski would have been available to either party to call as a witness, and neither of them has done so. Okay? Any question? Go ahead, Mr. Krause.
Thank you. Mr. Richards also mentioned that Attorney Binger talked about how all these people are liars, and he was acting like a whiny defense attorney. I don't know why that language had to be used, but Mr. Binger never said any such thing. He never called anyone a liar, except for perhaps Mr. Rittenhouse. And Mr. Richards talks about how, well, in the state's open, he heard nothing about provocation. Mr. Richards knows that is a specific thing, that instruction we get from the judge at the end of the trial.
If you can't argue the facts of your case, let's attack the attorney or the client. That's what's going on here.
Had we mentioned at the beginning, he would have objected. He would have objected. Now let's talk about this threat, this supposed threat. Mr. Richards talked about that gas station and showed the video, and it showed Mr. Rosenbaum at the end. Attorney Binger had said he's not in this video as it started, and you don't hear anything from him. And that is true. At the very end, he is seen standing quite a bit away from Mr. Balch and Mr. Rittenhouse. This is where that supposed threat happened. There's a distance between them. Next time the camera pans back, the protesters are pushed back, and you never hear this threat. You hear nothing. And apparently that is what the defense is accepting, is where the threat happened, although Mr. Rittenhouse actually does not accept that, because he said it happened at Block or 2 North. So they can't agree on when the threat took place. They can't agree on where the threat took place. And it's the only few seconds of that part of the night that is not on tape.
This is the problem when the prosecution gets last bite at the jury, because they can say anything and he can't respond. That's why this is really a bad case. To make this fairer, they should only be able to talk about things that he brought up, and anything that they challenge on him, he can come back and rebut. If they don't challenge anything he said, then he doesn't get to rebut. But they can totally attack and make all these negative statements, and he can't say a word. He's screwed. He's got his bite at the apple. He's done.
Anywhere. It's another concoction to give credence or to give weight that, oh, he had to defend himself against an unarmed man. There's some talk about how the defendant came around that Duramax and raised his gun. That didn't seem to be a contested issue in the case until the defendant lied about it on the stand. The defense themselves submitted an exhibit, number 41, in which it is denoted where the person that put that video together indicates Rittenhouse pointing gun at Zeminski's. I think it has a question mark. This was their exhibit. There was testimony from Detective Antaramian, and we showed this drone video. Now, but then the defendant won't admit to it on the stand, and then all of a sudden the defense has to fight it and talk about hocus pocus and make up little clever rhymes. The defendant could have told you the truth, but that hurts his case, and that gives us provocation.
Man, you guys got balls saying he's not telling the truth and it hurts his case. That's a pot calling the kettle black.
Now, I did have, on rebuttal, Mr. Armstrong put in two very blurry pictures. Mr. Binger didn't even mention these pictures in his closing because they're maybe the 5th, 6th, or 7th strongest pieces of evidence that Mr. Rittenhouse raised his gun. But the defense is seizing on them, and they inaccurately said that it took him 20 hours of work to do. He worked on that drone video for 20 hours. He made us multiple shorter videos of it. These images were the last part of that work. And that image does show Mr. Rittenhouse holding a gun.
He can't testify to what he's changing testimony. I guess they're going to say he's arguing.
It is blurry. Does it show every detail? No. But we thought it important that there at least be some still shot besides these videos. The second one I showed, again, is very blurry, but it's of the shooting. And you see Mr. Rittenhouse blurry, you see the puff of smoke, and you see Mr. Rosenbaum blurry, still very much upright. And that is why those pictures are given. It was the tail end of all the work that Mr. Armstrong did on this video. The defense seems very scared of these pictures because it helps to prove their client lied on the stand, and it shows that he provoked the attack. Now I would like to show you, I believe this is the full drone video, Exhibit 7.
I've never known a defendant to get on the stand and the DA not say they lied. Never. In the history of every trial I've been to. If you take the stand, the government's going to say you lied. They ain't got to prove it, but they're going to say it.
73. To see the raising of the gun, because it's the full video. I would encourage you, if you find it necessary, to take a closer look at the bigger TV. Please stop it. Now, if you see in this video, Mr. Richards wants to make it seem like the only recourse the defendant has in retreating is walking into this mob of people who are breaking cars. But look at all that open space that he has. At this moment, he could have turned around and ran in that space and gone right back up Sheridan, and everyone would be alive and everyone would be fine. Instead, he decides to start slowing down.
So now the DA is predicting the future. If he had done this, this would have happened. You know, if he'd have just turned around and hugged Rittenbaum, everything would have been okay.
And run into these cars in which he is supposedly trapped, which would be like being trapped in a Target parking lot. As you see, as we keep playing it, he goes around them no problem, and he goes right into this totally clear space that was available to him the whole time. He did not exhaust his duty to retreat. He did not exhaust all of his options.
There was no duty to retreat. He didn't have to retreat.
Now, I'm going to go to the video. I'm going to point something out. Mr. Binger is going to play it again, and I'll show you. This is in relation to Mr. Richards indicated that no one that attacked or that went after Mr. Rittenhouse in the second incident observed the shooting. That is not true. This video shows the person that is referred to as Jump Kick Man leaving the scene. And we have another view as well from another video, but I'll point that out. See this man in a wheelchair struggling to get out of the way? This is Jump Kick Man right here. He sees it. He's standing there the whole time. And he comes and he helps push the man in the wheelchair out of the scene. So he absolutely was there. He did see what happened. What's next? This is Exhibit 10. This is the Ford Fisher video. If you look after the shooting, it shows this individual pushing the wheelchair away from car source 3. There he is across the street, pushing the man in the wheelchair away out of the scene. does look better on the large television, but this is where he comes into the screen. This is one of the videos that Mr. Armstrong cropped for us in his 20 hours of work. This is slowed down by 50%, and it zooms in as good as possible, given the limitations of the video. I'll point it out up here, but like I said, it is better seen on the large TV. Make sure he freezes up. Oh, we got it. Or the chase, as you see him point. Mr. Rosenbaum does his jump. See the defendant slowing down, seemingly preparing to shoot. And look where that first shot is. Go back one more play, one more time. This is the zoomed in image.
When he says first shot, all 4 shots were fired. It's that fast.
That will eventually was shown. Look how far he's not reaching. He's being shot in the hip and falling. And he goes immediately to the ground, and the defendant sees fit to keep shooting at him, although he poses absolutely no threat.
Man, I hope the jury doesn't fall for this.
Again, 4 feet from the barrel of the gun, not from Mr. Rittenhouse himself. The smoke is already out. He's already upright. He crumbles immediately to the ground, but the defendant keeps shooting him. Mr. Rosenbaum turned to get shot in the back that way? No, he was even less of a threat. He was falling face first on the ground with his hips shattered. So yes.
He looks pretty close to me right there. He's at his feet.
He was shot in the back, and he was killed by a shot in the back, and it was the 3rd or 4th shot. Attorney Richards indicated that Nick Smith called the defendant. Nick Smith did not testify to that. He was never asked. We don't know who called the defendant to go to that scene. And despite the fact that there's this madman out there who's such a threat and is going to kill the defendant, he just saunters down there all by himself. No problem. He's not scared. This threat, if it even existed, was not taken seriously. He's a babbling idiot, as Mr. Lukowski said. Mr. Rittenhouse testified he didn't hear anything before he shot. He didn't hear this "fuck you." He didn't factor in the gunshot. There is no evidence that Mr. Huber did anything untowards that evening. They talked about pushing a dumpster, picking up pepper balls. That was not evidence that was ever submitted in this trial. I don't know where it comes from. No evidence that he told Gage Grosskreutz, "I had to shoot in self-defense." And Attorney Richards talks about how, well, Mr. Detective Howard testified in a certain way, and how he didn't talk about the drone footage or anything. He knows we got the drone footage, surprisingly, after Detective Howard testified.
Basically, he's going through every point he's trying to make and trying to discredit it, seeing if something will stick.
Guns do not have handed. There's not a left-handed or right-handed gun. So, yes, the demonstration...
That's not true. Well, it sort of is true. That's a pretty slick little thing. Guns are not left or right-handed. There are stocks that are left and right-handed, which makes the gun that way. Most guns eject away from the face, so if it's a left-handed gun, the ejection should move to the left. If it's a right-handed gun, the ejection should go to the right, so it doesn't come into your face. But, I mean, saying there's no gun left or right, it's kind of correct. It's more lawyer confusing, you know, a little bit of truth and a little bit of lies and whatever. All right, what happened here? I wonder if they're talking about the FBI stuff, because that's where it broke out last time.
Magistrates relied on the statement that saw it, that
Huh. Wonder if this is FBI cutting
told by
it.
others that saw it, that he was the shooter, and then he returned. So Gage Grosskreutz relied on the statement of Mr. Rittenhouse. Let's talk about a rush to judgment. Mr. Rittenhouse turned himself in. Are you supposed to wait days, weeks, months to charge murderers who we know murdered people? It's a red herring, as Mr. Binger said. It's throwing up red herrings, false, hypocritical arguments, and...
So it looks like what they did is, I'm just going to concentrate on my closing, and your whole job will be able to attack his closing, and then you're going to close just to attack what he says. That seems like the strategy they adopted.
attacks on those that Mr. Rittenhouse killed to try and distract you from the fact that he was not in imminent fear of death or great bodily harm, and he was not privileged to act how he did. We heard from Ms. Carrie Ann Swart. Now that Nathan DeBruin talked about jail, now we can try to smear Mr. Rosenbaum more, although there really is no dispute, or was no dispute, that he came from a hospital. He's carrying a hospital bag. Ms. Swart testified that she talked to the hospital about how he would be released, that he went to this hospital. She knew he was coming home from the hospital. She knew it was in the bag, and he showed that picture of it backlit against the fire, trying to make it seem sinister. She talked about how there are medical papers in there. And we did that image again. Mr. Armstrong did this image for us, where you can get a little peek in the bag. And I would argue you can see medical papers. Though that big image they see, looks like rolled up medical
How do you know that ain't jail papers?
records that you get when you're discharged from a hospital. And Ms. Swart testified that he was given medications that day. Perhaps they didn't work. Perhaps there was a bad reaction. I don't know. I'm not a doctor. But he was given that day. He could not get the ones for future days because things were closed. Balch did not testify that he thought there was anything sinister in the bag. He said he said something inaccurate at the time, but he said that he saw shampoo bottles and a water bottle. Mr. De Bruin, he did take some nice photographs, and he clearly wanted the world to know that he took some nice photographs.
Discredit him. See, he just wanted the world to know. He's still a bad guy.
He's really more relevant to Mr. Ziminski. And he apparently, this is the photo of the bag, you can examine that further. Mr. De Bruin must have some problem with police and DA's offices.
Oh, so it's his fault that he doesn't trust the governor. I don't trust the government either, dude. How about that?
Most of the detectives, he doesn't give a full story. He says, he testified to this. This is not me saying anything. He forgot that he was so nervous because the door of the police station still had an unrepaired window. That caused him such nervousness that he could not give a full statement. He meets with us in a very polite, short meeting. He has very little relevance to this case.
Oh, it's polite and short because you two say it is? You two bullies get a young kid by himself where you have home court advantage and you're scaring the shit out of him and you're telling him you're going to call him and you're trying to shove a phone in his face to get him to change his testimony, and you two say it was a really nice setting? Gee, that's not shocking to anybody.
Case that we knew about. And yes, we showed him some videos. Is this Josh Ziminski? Oh, no, it's not. Okay, would you see any of these other pictures? Yes, you don't know it's Josh Ziminski.
Isn't it funny that they didn't record the conversation? Neither of them did a report on this so-called interview. So you're interviewing people and you're not taking notes, you're not recording it, and now we just have to take your word for it. You sound like the FBI.
Okay. Somehow that's us getting to change his statement. What's that? We show him pictures, videos, say, is that Josh Ziminski? I don't know. We show him other pictures. Do you recognize that as the same person? Yes. That's not going to change his statement. We had him read a statement. Do you have anything to add to it? No. The next day, he goes over to Mr. Richards' office. All of a sudden, he knows all this extra information that wasn't in his statement. Oh, but he was so nervous meeting with us because we showed him a video or photograph that he took of Joshua Ziminski. And then what does he do? He goes and hires a lawyer very closely connected with a gossip blogger who attacks my office on a regular basis and who is very pro-Rittenhouse. Another just funny coincidence in this case, just like how Mr. Hernandez, who doesn't live in the state, could hire any of the thousands of attorneys in Wisconsin or tens of thousands of attorneys in the state. But no, he hires an attorney who Kyle Rittenhouse's defense team has already paid money to that firm.
Oh my God, man. The deceit and lies that he's throwing out there, none of that means anything, and he knows it.
What a coincidence. So Mr. De Bruin doesn't tell us any information, then tries to attack us, and then tells the defense a lot more information.
So everybody's a liar and bad except these two guys and their witnesses. He's bad. His attorney's a firm, the firm that represents. Everybody's bad except these two. Wow. Never heard that before.
Mr. Rittenhouse denied pointing a gun at the yellow pants man, said he was being sarcastic. Well, Mr. Richards basically just admitted he did point the gun. So which is it? We know that Mr. Rittenhouse was going around that night trying to be a paramedic, a policeman, and a fireman without receiving any real training in any of them. Tough job to do all three at once. And he went around with his...
That's not true. He did receive, he was a police explorer, so therefore he got some training in police. He was he worked for the fire reserve, part of the department, and got some training with them. And he's been to first aid as a lifeguard. So he did have training in all three of theirs. Granted, not extensive training, but he had training, and he slid it in that he had no training in none of those.
His gun, trying to scare people, to intimidate them, to not do minor property damage.
Minor property damage. $2.5 million in cars got minor property damage. It wouldn't be minor if it was your freaking home, Jabba.
He's a chaos tourist. He was there to see what was going on, act important, be a big deal. And then the moment a little bit of that chaos comes back at him, he cowardly shoots a man instead of fighting back.
Nah, he's a coward.
You put yourself in this situation, you know it's going to be out of hand, it gets a little out of hand, someone is chasing me, and you have to shoot him. That is not privilege. That is not reasonable. And that is not what any reasonable person in the defendant's shoes would have done. Because you have this rock in his hand, there's no evidence of there being a rock in that hand. Now, there's talk about...
There's no evidence that he didn't have a rock in a hand either.
How the defendant maybe have re-racked his gun. We don't see that in the video. We don't know what he did. But we do know that as Gage Grosskreutz is sitting there with his hands up, the defendant turns over his gun and is looking at it and is doing something with it. The defendant admitted to this, that he looked at the gun. Fully reasonable that Mr. Grosskreutz could have assumed that he was re-racking and preparing to fire.
Yeah, that's the only reasonable thing, right? Because that's the only thing that fits his story. Couldn't have been nervous, couldn't have been dizzy. He was knocked down, just kicked in the head, hit in the head with his... Couldn't have been dizzy, a little disoriented, losing his balance. No, 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 no. The only thing reasonable is what the other felon saw. What a couple of freaking liars.
And it does not mean that a unspent shell casing has to be on the ground. Officer Bray testified that she shot AR-15s. She knows AR-15s. There's if it jams and there's an unspent shell casing, the re-racking will take out the unspent shell casing. It does not have to be a live round. I don't know what he was doing with his gun, but it's certainly reasonable for Mr. Grosskreutz to interpret it that way. And then what does he do? He doesn't step back and take a firing position and shoot. He didn't shoot him 5 to 6 seconds earlier when Mr. Rittenhouse was being an active shooter, after having killed his second person and shot at his third. He would have every right to have...
There's that active shooter again. Let's call him an active shooter. I'll just keep saying it. Somebody will believe it. See, to me, that's just unethical. Nobody believes that Kyle was an active shooter. Nobody.
Stopped Mr. Rittenhouse's activities at that point. But he didn't. He came up closer. He surrendered, and he said, he believed his surrender was not being accepted. Who shoots someone like this? Is he trying to shoot his own hand off? He never does anything about an actual position to shoot that gun. And as Mr. Richards admitted in his closing, when it's pointed at his head, his arm is already blown off.
So he just said when his witness raised his hands, he was surrendering, and everybody knows that. But when Kyle raised his hand, he got pepper sprayed, and the cops go, we don't take that as a surrender. Which one is it, Mr. Government Boys?
We're supposed to be so scared of Mr. Grosskreutz with his Glock when the defendant is holding a loaded AR-15.
I'll give you an AR-15 and I'll take a Glock. Want to test that theory, Jabba?
Then there's this preposterous argument that, Kelly Zeminski is holding a flashlight. It must be to bash heads. Certainly no one carries flashlights at night to walk home in the dark or walk to your car in the dark. I take my dog for a walk. I'm looking to bash in heads? No.
I'm thinking if you're walking your dog, you're looking for somebody that threw out scraps.
We hear about how, this vicious kick that, if you watch it live, did not seem to make much contact. Spun him 180 degrees. That is Kyle tracking him with the gun and shooting at him. He's moving as he's moving. That is not the force of the kick. And the video makes that clear. But again, we're grasping at straws and we're throwing out red herrings.
So we know now, the DA, the government knows how much force is with the kick and what happens. Wow. Man, those guys are good. They ought to work for the FBI.
And now, a skateboard is a deadly weapon.
You damn right it's a deadly weapon. Let me hit you in the back of the head at the base of the spine or in the temple, and we'll ask one of your heirs if they think you would have changed your mind, because you're going to be checked out, dumbass. Of course it's a deadly weapon. Anything that can be swung. A bat, a stick, a club, a pipe, a skateboard, a 2x4.
Someone should tell the parents and grandparents and Santa Claus giving skateboards this Christmas about how they're giving their children a deadly weapon.
Oh my God, are you serious? Now we're going to ask Santa Claus what a deadly weapon is? This murder trial ain't even serious. These guys think this is a freaking game, showing movie clips and asking Santa Claus what a deadly weapon is. How can anyone still have any faith in our judicial system when these two idiots are the stars of the DA's office? Wow.
I guess they should get him an AR-15 instead. It's just preposterous. And yes, Mr. Huber was acting heroic in holding down that and taking that skateboard and trying to hold him down and trying to take that gun. And what happened? The gun stayed attached to Mr. Rittenhouse. Because when the defense concocted this, they were trying to take my gun story, they left out that it is literally strapped to him. He shot an unarmed man 4 times because he was so scared that Mr. Rosenbaum was going to take the gun away from him when it was attached to him. It is an absolute red herring. It is an absolute ridiculous argument.
Ask any cop, if you grab my gun, deadly force is authorized. You don't even have to get it out of the holster. If you put your hands on my gun and try to take it, deadly force is authorized, and me or my partner can put a bullet in your head, and it will be justified. And now he's trying to make it because he's got a sling. He can't be in fear of losing his gun. Just out and out lies. I mean, it's just sickening.
Imminent threat. Not, oh, in 5 minutes after we get beat up, then I might be a threat. Imminent threat. You've heard all the videos. I'm not going to go into it any more great length, but when you listen to the crowd as Mr. Rittenhouse is running, they start yelling after he's running when they're screaming, get him. Also, as people are approaching him at the end, they're asking, why did you shoot him? Why did you shoot him? These are people that were provoked because they witnessed an attack or heard shots or heard he was attacking, and they took action. As Mr. Bringer said, I probably wouldn't do it either.
Well, that's because you guys are such good guys or because you're both pussies. Either way.
But that they did it is brave, and they did not deserve to be killed.
Yeah, the criminals who were burning, looting, carrying guns all lawfully, hitting people in the head with a skateboard and kicking them in the face when they're on the ground. They're the heroes. Welcome to Kenosha DA's office. Man, this DA who these guys boss, he should be unelected next term. The people of Kenosha ought to freaking say, if you can't control these 2 idiots and you encouraged and wasted our money on this and you got guys lying like this, you don't deserve to be. I hope they vote his ass out next election.
Kyle Rittenhouse has such strong ties to Kenosha, but he needs Google Maps to find a business he says he's driven by every day. He supposedly knows Kenosha so well and is such familiar with Kenosha that he doesn't realize you can walk 1 block either way to get back to the car source. He didn't want to go back to the car source. He wanted to go see what was going on. He wanted to stay in the action. He wanted to continue to do things that would make him feel big and make him feel important.
Now we're just making up shit. No evidence of that whatsoever. We'll just make shit up.
These minor injuries we've heard the defendant have, again, Mr. Richards misstated the standard. It is not could have caused great bodily harm or death. It is not likely to have caused great bodily harm or death. It is imminent threat of death or great bodily harm. Where is that when you get a couple scrapes?
Couple of scrapes. Skateboard, kick to the face, on the ground, hitting the back of the head with a brick, and a guy's literally grabbing your gun, trying to remove you, committing armed robbery. Armed, hitting you with a skateboard, and then grabbing your gun. Armed robbery. And he can't defend himself.
Everybody takes a beating sometimes, right? Sometimes you get in a scuffle and maybe you do get hurt a little bit. That doesn't mean you get to start plugging people with your full metal jacket AR-15 rounds and no, bullets are not bullets. And we heard testimony about that. Mr. Richards mentioned this in opening, but apparently he's noticed that the evidence doesn't bear it out. He talks about this, how Mr. Rosenbaum put this shirt over his head to hide his identity because he's going to go ambush Kyle Rittenhouse. Well, then obviously watch the videos. He's had that shirt on his head for some time. Whether it's COVID, this is all pre-vaccine as we know. Whether it's tear gas, whether it's fire, whatever it is, he's using to protect his face, not as some evil plan to get Kyle Rittenhouse.
Yeah, because he's such a great guy.
They're setting this fire, and they begin walking down Sheridan. There's no evidence that they knew he was coming. There's no evidence that they had any plan to get him. I'd submit to you that the Zeminskis and Mr. Rosenbaum were doing what they were doing all night. They were going to go bash that Duramax or start or stoke a fire. Kyle sees this, and then he runs onto the scene. That's clear in the FBI video. He runs onto the scene. He puts down the fire extinguisher. He raises up his gun. Mr. Rosenbaum yells, gun, gun, gun. Why else would he yell that? It's very possible to...
There's no evidence that he yelled it. They don't know who yelled it. But, I'm sure it's just a mistake by the DA because they would never intentionally lie or intentionally misstate the evidence or intentionally try to mislead the jury to put somebody in jail just because they can, just because they have the power. No, they would never do that. We should just believe them.
while he was yelling friendly, 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 he's doing so while holding a loaded AR-15 at the Zeminskis. Mr. Rosenbaum was going to chase him out of there to end the danger. And Mr. Richards boasts that, something along the lines, you won't do shit, motherfucker. Well, Mr. Rosenbaum is wrong. Oh, that's an attaboy right there. Way to kill someone unarmed because you won't engage them. He raises the gun, he provokes the attack. He has to retreat. He has to exhaust all remedies before he regains the right to even use self-defense, not even to use deadly force. That's a whole other separate question. He does regain the use of self-defense if he exhausts all options. He does not. He could have ran a different way. He could have fought. He had all sorts of different ways to exhaust his options. He did not do it.
Are you really the person to be talking about somebody running? Because my guess is you don't have a whole lot of experience in running too far, except maybe to the refrigerator. And you're going to start telling other people how they could have ran.
As I said in the beginning of my closing, I don't think you need provocation. An unarmed man chasing you, and you shoot him 4 times as he's falling, you kill him as he's falling in front of you, because you don't want to physically defend yourself, that's first-degree reckless homicide right there. And Mr. Richards kind of plays games with the name reckless. Reckless means not intentional in this circumstance. And you can read the jury instructions, you can come to your own conclusions. And firing an AR-15 in any circumstance like this shows utter disregard for human life. There's no other explanation for it. If you're shooting an AR-15 at close range of people, you have no disregard for human life.
Really? I know a lot of cops that have been shooting people with their ARs. Hell, they're shooting their ARs out of their car while they're driving down the road through their windshield with other people on traffic. And I've never heard this argument against what they do. Shocking.
That's not really in any dispute. I want to leave you with this. The meaning of reasonable doubt. I'm going to read portions of this instruction. Obviously, you'll have the whole instruction. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. That's what the defense is asking you to do, to guess what Mr. Rosenbaum was doing, to speculate what Mr. Rosenbaum was doing, to speculate and guess what Mr. Huber and this unidentified man were doing.
And you're asking them to guess and speculate what Rittenhouse was doing, right? No. You got all the answers. I forgot.
We don't know because he killed 2 of them. All we can look at is the evidence and see him standing pretty much straight up or exactly straight up when he was shot in the hip and immobilized. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. The defense's whole case has been trying to stoke sympathy for Mr. Rittenhouse and showing how everyone else was just a terrible person. Every life counts. Every life matters. If people did bad things that night, they could have been prosecuted. It's not up for Mr. Rittenhouse to be the judge, the jury, and eventually the executioner. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. There's a lot going on in this case. We all know that. We all knew that from the day we walked in on November 1st. But this verdict should be about what the facts are and what Mr. Rittenhouse did. That's what the 12 of you who go to deliberate will go and decide. You are the fact finders. You decide what is beyond a reasonable doubt. You decide what he is guilty or not guilty of from this menu of options that you now have. An imminent threat. The only imminent threat that night was Mr. Rittenhouse. He was not acting in legal, justified self-defense. He's guilty. Thank you.
Thank you, Mr. Krause. Members of the jury, the time has now come when the great burden of reaching a just, fair, and conscientious decision in this case will be placed wholly with you jurors selected for this most important duty. You will not be swayed by sympathy, passion, prejudice, or political beliefs. You will disregard any impression which you may have regarding what you believe to be my opinions on the guilt or innocence of the defendant. You will disregard the claims or opinions of any other person or news media or social networking site. You will pay no heed to the opinions of anyone, even the President of the United States or the President before him. The founders of our country gave you, and you alone, the power and the duty to decide this case based solely on the evidence presented in this court. You will fearlessly keep faith with those who have entrusted to you the fair rendition of justice and the protection of our freedom. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind, and as upright citizens, to return just and true verdicts. You will decide only whether the defendant is guilty or not guilty of the offenses which are charged. Any consequences of your verdict are matters for me alone to decide and must not affect your deliberations. It will be for you to determine whether the defendant is guilty or not guilty as to each of the offenses charged or submitted. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other. This is a criminal and not a civil case, and therefore, Before you can reach a verdict which may lawfully be received, it must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. That presiding juror's vote is not entitled to any greater weight than that of any other juror. We're going to stop at this point, and I'm going to ask that you return tomorrow. I'm going to let you take a vote. When you want to start tomorrow? You can choose 8, you can choose 8:30, you can choose 9. How many would be in favor of starting at 8:30? How many want to start at 9? I missed 8, didn't I? How many want to start at 8? How many would like to start at 9? All right, that's the clear consensus. Well, it's not a consensus, but clear plurality, probably majority, I think. And so we'll start at 9 tomorrow, as we have been. The case is ready for decision by a jury of 12. We don't have that. And it's just as important as ever. I'd say more so, except that it was always important, that you not discuss the case with anyone. And you won't have to resist that much longer now because you'll be able to decide the case. Please don't read, watch, or listen to any account of the trial or anything to do with the trial. And tomorrow morning we'll assemble, and as I indicated earlier, the tumbler over there will be used. All of your numbers will be placed in there. And 6 of the, well, assuming there are still 18 of you, 6 of them will be drawn out. And those persons will be held in reserve. They will not join the 12 in deliberation. We're going to retain you here in the building, those of you who are...
So if they're going to draw 6 out, that's another factor that they could choose literally the 4 or 5 people that were going to vote not guilty, and those people will be the alternates, and they don't get to vote. Or they could choose 4 or 5 people that were going to vote guilty, and now they don't get to vote. Wow, I don't know about that.
Not selected. We'll stay here in the building, and in the event that your services are needed as we continue the case, and then the 12 of you who are the jury selected will commence your deliberations at that point. So, again, no talking about the case. Please don't read, watch, or listen to any account of the trial. Any questions, anybody? Enjoy the evening. We'll see you tomorrow.
All right. That's it. The jury has it. They'll start tomorrow. I'll try to go live when I hear their verdict. Normally, they get 30 minutes to an hour. Sometimes it's longer if they can't find somebody because they want the families to be able to get in there. So as soon as the jury says, we have a verdict, they'll start calling everybody. The media will put out, the jury has just reached a verdict, and we're going to be hearing it within the next hour, hour and a half. So hopefully if I hear that, somebody else hears it and texts me. If you email me, I probably won't get it. But anyway, and then I'll try to go live for the reading of the verdict. All right? Well, enough there. Y'all have a good one. My opinion, the defense gave the best closing, but the prosecution has all the benefit of first and last, and they created a lot of confusion and filled it with a lot of lies and a lot of mistruths, and it's very easy. Remember, the prosecution was going to try and sneak in an unlawful gun until the judge called them on it. They were going to let the jury decide on an unlawful gun, knowing they didn't have to go measure the gun. They knew it was legal. And until the judge called them on it, they didn't drop the charge. This is probably one of the most, the case I talk about with Jeff Reisig, YOLO DA, that tried to hide evidence on that death penalty case, was pretty egregious to me. And then they put up lieutenants that literally lied, on a stand. And so, that was pretty egregious. But this has got to be right there behind it on what these 2 attorneys have been doing as far as sleazy and low down and dirty. All right. We'll see y'all on the verdict.